Yes. Are you Seersucker and
In honor of you?
no, in honor of August Seersucker in May. Record. Good morning. It's 16 August 2022. This is the second day of a special meeting of the Taxicab Authority Board for the state of Nevada in the matter of the independent cab APN application. The record should reflect that the administrator is present, that board members Becker, Soderberg, Vice Chairman Thompson, and myself, Dan Reeser, are present. Council and the parties are present. Would you join me in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The record should reflect that notices and affidavits of service have been accepted and are in the record. This matter has been previously properly posted in accordance with the open meeting law, correct, Madam Secretary? Yes. And so we will commence with public comment. This time is set aside on the agenda for those members of the public who would wish to address the board on matters within its jurisdiction. No action may be taken on those matters, but we, of course, are interested if members of the public want to provide comment. Is there any member of the public that wishes to comment to the board? Hearing none. Oh, I'm sorry. May you make a public comment? Certainly you may.
Good morning. For the record, Katana Martinez, Management Analyst 2 for the Nevada Taxicab Authority. Just two things in reflection of the hearing so far. In terms of the system for our handicap or disabled rides, I'm speaking from my personal experience. Last June, I had lunch at a Popeyes on Maryland and Flamingo, and there was a man who was throwing a tantrum. He was in his late 60s, and finally didn't know what the commotion was about, but he finally came up to me with a lot of shame and asked if I could give him and his wife a ride home. They have been waiting for a cab for 2 hours at that Popeyes to shop for a fan because it was, 117-degree weather, height of the summer. And without revealing who I was, I did give that person a ride. That was actually during my lunch break. I have heard one too many stories. I'm coming here on my own accord. And I just think that there's something to look into with the kind of service, if we all truly care about serving the community that we say we are. I do believe that there's something to look into, and I know that service is currently being provided, but there's definitely room for a lot of improvement on the matter. And that's just one of many. I have my own staff or coworkers who are well over within that age that would rather take an Uber than a taxi, knowing that they're going to be not picked up, or not dispatch is not going to go and take that ride over there. I want the public to be aware of that, and if you are listening, come forward and maybe speak out on your experiences. This is not something that we could turn a left cheek on, and I want to be looked in the eye and told that something is being done about this. And again, of course, being part of Taxicab Authority, it's just we would do what we can. I'm willing to do what I can to help and serve my community as well in the best way that the opportunities and limitations that I'm given. With that said, I do hope that we make the best decision that we can today, and thank you for your time.
Thank you. Is there any other member of the public who wish to address the board? Hearing none, we'll close public comment and resume the hearing in the independent cab matter. There's one housekeeping matter I'd like to take care of first. Exhibit 4 is Upner's testimony. I intend to admit unless there's objection. No objection. No objection. Exhibit 4 is admitted. Is Exhibit 3 ready yet?
I just actually spoke with Mr. Trapton, and I asked Attorney Ricker, maybe we should review it to make sure that it confirms before I give it to you guys to go through the final look through for the admission of it, if that would be okay at the next break.
So have you provided copies?
No, I've got them right here.
So, yeah, I would like you to provide copies to counsel
Okay.
and also to Mr. Ricker.
Ricker and Ashish.
I mean, really, you're,
Okay.
not me, unless
Right.
you have an extra copy, but I'm
No.
not necessarily.
Opposing counsel and Mr. Ricker. Right now, so that they have the opportunity to review it. And my intention is to take up that issue no later than 1 p.m. this afternoon.
I have a matter that,
Certainly.
okay. Mark Trapton on behalf of Whittlesey Taxicab Company and Henderson Taxi. I am making a motion to dismiss this application pursuant to NAC 706.3959. That regulation gives this board the authority to dismiss this application during a hearing. It also gives me the ability to make an oral motion. The basis for the motion is that I contend that this process with the late filing of the amended pro forma and the revised application has tainted this entire process to the point that it's irreparable. As I alluded to yesterday and contemplated all night, I've thought through a myriad of other ways that I think this could be addressed. And I don't think that there is a fair way to address the fact that this application has been amended. And primarily because it's been distributed, it's been reported on by Taxicab Authority staff, and it has changed the entire complexity of this process. This application is a completely different application than was filed in 2019. And we didn't know about it. We, the interveners, who have a direct and substantial interest in this proceeding, did not know about this revised application until yesterday. The second reason that I contend that a motion to dismiss should be granted is, in addition to the fact that the amended application has tainted the entire process, several of the discovery orders issued by this body's hearing officer were violated by the late filing of the amended application. There were deadlines that were established for the identification of witnesses and documents. Any such documents or amendments to documents should have been filed before the deadlines. Deadlines were certainly, I don't have the exact date, I believe it was November of 21, but they were certainly before July of 22. One of the witnesses that came out through Mr. Carson's testimony was a witness that we had never heard of before. And that's the person that he testified to yesterday. He plans on possibly having managed independent cab company. It would have been nice to know the identity of that person during the discovery process so that we could have taken that deposition, inquired of that person's experience. That was a new breaking development as of yesterday. clearly that's in violation of the discovery in this matter. So for those two reasons, I ask this board to consider my motion to dismiss this application on behalf of Whittlesey Food Cab and Henderson Taxi. Thank you for your consideration.
I will join in that and just adopt what Mark just said. I thought one of the weaknesses of this application was after Desert Cab responded to interrogatories, pointing out all the faults with the pro forma and states that there'd be an amendment. And it surprised me that it wasn't. But now we learned that it was. And it was disclosed to us yesterday afternoon. So I joined.
Mr. Gibson, on behalf of YC Yellow Checker Star, I join in Mark's motion. I would just also like to point out, not only is the amended pro forma an amendment, it is a complete revolution of his proposed business model. His original business model that we conducted discovery on and we had our disputes over for the better part of 2 years involved a leased operator. The new pro forma that was submitted to this board, which is in all of the board's material, is an employee structure model. That is a completely different business model, and having less than 24 hours to evaluate that is insufficient time to properly prepare to dissect this pro forma and all of its potential deficiencies. And I don't believe that there any type of curative instruction, curative removal of this would satisfy the requisite amount of fairness that is necessary to my clients as that have a substantial interest in this application. And I would join in the motion.
Mr. Trafton, what's the is the standard of review on your motion to dismiss?
I don't understand what you mean. It's,
Are you making a motion under rule, by analogy, under Rule 12 standards? Are you making a motion?
well, no, okay. I'm not making a motion for failure to state a claim. I'm not making a summary judgment motion that there are no facts in dispute. I am making a motion to dismiss based upon NAC 706-3959, which gives the
Say it one more time.
NAC 706.3959. Yeah. If anything, I would tie this to the sanctions allowable under NRCP Rule 37, which pertains to discovery and the abuse of discovery. I think that most closely applies in this situation. And one of the sanctions under Rule 37 is the ability for the judicial officer or the hearing officer to dismiss the action. And because, like Mr. Gibson alluded to, I don't see any curative way to resolve this. I believe that a dismissal is the only remedy that makes sense. And so I guess if I'm trying to tie it to a standard of review, then it would be Rule 37 in the NRCP.
Mr. Carson, your response.
Thank you, Mr. Chair. NAC 706-3959 is not a taxi cab authority rule. That is a practice before the Nevada Transportation Authority. That is not binding upon you as the taxi cab authority. Motion is flawed from the very beginning based upon just that alone. And as we discussed yesterday, this isn't an amended application. It was asked for and provided. Discovery had been completely done and stuff like this. I don't care if it's relied upon or done anything like this. No matter what number I threw out there on any kind of pro forma is going to be contested. I understand that. It's a pro forma. Let's get to the bottom of really what this is. Is a pro forma an actual financial statement? No, it is not. It is not governed by generally accounting principles. It's not. In fact, if you look up the definition, I said it's a hypothetical assumption. How can a hypothetical assumption be used to tear apart an application of an otherwise fit, willing, and able applicant? If I were to put down the company was making $1 million, not good enough. If I would put it down that it's not making money, net profit of no money, they would say that's not good enough because it's not compensable. The Taxicab Authority has one financial requirement. One is that the owner maintains a 20% debt to equity ratio. What does that mean? It means if I don't make money, I have to report that net loss under my equity section of my balance sheet. My retained earnings goes down by whatever my net operating loss is. Now that affects my equity, my debt to equity ratio. Now, if that loss was $200,000 and drops my debt to equity below 20%, what does the regulation state? It says I have 12 months to get that amount back up to 20%. The legislature, you guys have already established that, hey, is there a possibility that a taxi cab company doesn't make some money? Yeah, I mean, every business runs the risk of not making money. But what is the cure? The cure is make sure you have 20% in your company in equity. And why is that? To make sure you can pay for insurance, make sure you can pay for tires, make sure you can pay for your cars. That's the number one goal, is safety, is protecting the traveling public. And if statute, not me, not you guys, the legislature says, what is a safe amount that this person must have? And it is 20%, the only financial requirement in the Taxicab Authority's regulations and rules. And if I fall below that, Daryl, the financial analyst, is going to see my annual report every year. And it's going to be assets divided by liabilities, but over to, hey, your debt to equity ratio is 18%. What are you going to do about it? I have 12 months to bring that up. Or I could do that today and say, how much is it up? 18%. Okay, I'm going to cash infusion $100,000. That raises my assets up by $100,000, raises my paid in capital by $100,000, and in return, my debt to equity goes back up to over the 20% that's required. Look at the qualifications, the standards. I implore you, 8827 and the NAC, I can't think of it right now, the one that says I have to be good moral character and all that. But show me anywhere that it says I have to have an accurate pro forma. It doesn't. And I said that before, I've said it before. It's a pro forma. If you want to consider it, consider it. If you don't, don't. Let's talk about this. Discovery orders and failures. When was the discovery cutoff? Can anybody here tell me when the discovery cutoff deadline was? Had this conversation in front of you guys on my appeal. I all believed it was November of 2021. Hearing officer said, no, it's not. So when was the discovery cutoff? When is it? Can anybody tell me when that was? Because I was getting documents from these guys up and through 2022. I thought it was done. I'm still getting documents. Now let's talk about that. Depositions. Oh, we just found out about this Tony Bohr hogwash. They knew I owned that company with their little public records requests and everything to the NTA. They knew who he was. They knew who my operation guys is. But why did his name come up now? Let's talk about why his name just came up now. We're all lawyers here. We all know this. In June 28th, 2021, I filed my witness list and my exhibits that I was going to introduce. One of my witnesses, Mark Friedman. Mr. Friedman is considered an applicant to become the general manager if the application is approved. Mr. Friedman will testify to his experience, the transportation industry's qualifications, and here's his attached CV. Mark Friedman, care of Attorney Brent Carson, 7935 West Sahara Avenue, Suite 101, Las Vegas, Nevada, 89117. We all know what that means. That's my witness. He's a manager, decision making. I get a call from him last week saying one of the interveners, general managers, just called me and talked about this application. I haven't spoken to him in over 10 years, but all of a sudden they're giving me a call saying, hey, what's going on with this application? Are you still going to be the general manager? That's BS. That is right there a breach of ethical violation. They know I'm an attorney. They know his name based upon my disclosures, and my disclosures list him as my witness. If they want to speak to him, they have to call me. They ask me why I don't give people names. I'm not going to give them any names. I have qualified applicants that would be a manager for my company right now today if I had it. Am I going to tell them? No, because they're going to call them, harass them, tamper with them. I don't know. For them to say I'm abusing discovery is absurd. I will file a counter motion to that, moving to strike their interventions for the violation of the ethical rules. Mr. Thompson said, we just want to get to the facts. Let's get to the facts. I'm sick of all the moving, let's dismiss this, let's kick them out. Let's do it. We're here. I understand if they want to look at this and criticize my new pro formas anymore. If they want time, give them time. But I've come 2.5 years with this. And I'm not going to back down.
Anything further?
Now,
Mr. Carson is correct. I cited the regulation pertaining to the NTA. The applicable one for the Nevada Taxicab Authority, I believe, would be NAC 706.912, miscellaneous applications for review. But other than that, nothing further.
anything? Mr. Gibson?
Oh,
you're thinking.
Oh. I will address one of the points, or a couple of points that Brent just made. He talks about he's an attorney. He understands the requirements to disclose materials as intended to be used during the course of a trial. Let's call it that's what it is. That's what this is. And he didn't disclose that to the other people and other parties involved in this case. And he did so intentionally. Point one. Talked about, I don't know who contacted Mark Richard, I believe is his name. I don't know the answer to that, but unless Brent Carson is his counsel of record and is representing him in this particular matter as his attorney, there is no necessary privilege in that instance. You're allowed to talk to witnesses. Period. It doesn't sound like if he intended potentially for Mr. Bohr to be his general manager as a possibility, he should have listed it. And he didn't. I believe. And he talks about the pro forma, and he talks about the fit, willingness, and able. Part of being fit in this taxicab authority has a duty to ensure that anyone that is issued a CPCN can operate that entity properly. Not just for 12 months, but for longer than that. And that goes to part of the fitness. The business plan is his fitness to operate the company. And if the business is going to fail financially, this taxicab authority has a duty to prevent that from happening, to protect the public, and to protect not just the writing public, but to protect anyone that potentially were to go and work for that company. And dropping this bomb on us yesterday, which he didn't even, and I would like to point out, He didn't talk about his revised pro forma during his opening. He didn't talk about his revised pro forma during duress. It only came out during cross-examination. What's the purpose of cross-examination? To reveal the truth. What was done is fatally flawed and has prejudiced all the interveners in this particular action. I don't believe there's an alternative but to dismiss the application. And I submit.
Thank you. I believe the motion is cognizable under 233B 21 and 123, but not under the rules of this agency. The agency has not adopted regulations for motion practice, but I believe they exist under 233B. I believe that the standard of review here is a discovery sanction. It is not a 12B motion, nor is it a 56 motion. A discovery sanction motion is addressed to the sound discretion of the body hearing the matter, the tribunal. As to the factual matter that I think is before the board, we have not an amended application. We have an amended pro forma, actually a set of pro formas showing an alternative business plan, the original business plan, which was a lease model, and an alternative business plan, which is an employee model. Those were produced at the request of the administrator for the purposes of doing a background review. And that was within the administrator's discretion. There may well have been a discovery violation here. But in my view, in an administrative proceeding, this particular discovery as to the pro forma is fully and completely curable. I read all of those documents last night. I know what I would expect to be the cross-examination today. And I believe that cross-examination can explore whether he's fit, willing, and able, or he's otherwise compliant with any other regulation. We are not in a jury trial. This is an administrative process. Procedures are relaxed. Evidence is relaxed. As to the disclosure of Mr. Bohr, I can only tell you my assessment of that evidence. It was, in my view, one of the more flippant comments that Mr. Carson made yesterday, because he was responding to a question I asked, which is, who's going to manage this? And he said, well, if I need to, Mr. Bohr. Well, in my view, my colleagues, last time I checked, the 13th Amendment to the Constitution does not allow indentured servitude. So whether Mr. Bohr will ever serve in that position is up to Mr. Bohr. And so the state of the evidence right now is he doesn't have a manager. And I am quite confident in the capability of the three interveners council to cross-examine on the differences between these two sets of pro formas. So my recommendation to the board as the presiding officer is that we deny the motion, or in the alternative, if a member of the board wants to hear all of the evidence before making a determination on the motion, that we take it under advisement until after closing arguments. And I'll entertain a motion of the board on how they want to proceed.
Mr. Chairman, I will make a motion to deny the motion to dismiss. I agree with the moving parties. This is pretty serious. But I don't think it goes to what they're talking about at the moment. It bears strongly, in my mind, on our review of the standard for fitness, but that's not part of this motion. I agree with you that we're in an odd little pickle here, is that we have something that was not right, and we don't necessarily have a rule that would cover it. So I agree we need to move forward and deal with this issue as part of our deliberation over all of the things we need to look at to make a determination on a approval or non-approval of this application. So I will move, saying that, I will move that we deny the motion to dismiss.
Second.
I second.
Any further discussion on the motion? All those in favor signify by saying aye.
Aye.
It's unanimous. The motion's overruled. You may, I think we are at the point where you may cross-examine Mr. Carson, and even having tried many a jury trial and a bench trial myself, I will give you 15 minutes to collect your thoughts. Thank you.
Hello? Yes, hi, how are you doing?